Court calls the case of Arbor Meadows versus May Hall.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Have her now.
Miss Hall?
Yeah.
No, I'm sorry, she's not checked in.
May Hall, also known as Lucille Hall. No response. Would you like to take the call?
Yes, Your Honor.
Raise your right hand to be sworn. Pardon?
There is a consent judgment, Your Honor,
Yes, sir.
but the defendant has not appeared. We submitted it. She signed it, but she was informed she needed to be here to place her consent on the record. If the court is willing to take the consent judgment as presented.
I can't.
I understand.
That way. Raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead.
Thank you, Your Honor. This is a termination of tenancy case at a manufactured housing community. Defendant was provided with notice at the first hearing. Of the second hearing, the defendant has several outstanding violations for correcting the exterior of the home. The corrections have not been made since the filing, and we'd ask that the court issue a default judgment with a writ date of June 23rd, 2025.
Judgment to the plaintiff, that is by default.
Thank you, Your Honor.
Possession, no redemption amount, writ to issue as indicated in the judgment. So what I've done, so the record's clear, is I've taken the consent judgment, entered it as a default, and
Thank
then
you.
signed it.
Thank you, Your Honor.
Court does call the case of Arbor Meadows versus Maria Herrera.
Good morning, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
All right, you've been sworn. I see that this is the same type of circumstance. You may proceed.
Thank you, Your Honor. We'd ask for a default judgment, similar circumstances. The previous case, it's a termination of tenancy for failure to remediate issues on the exterior of their mobile home. No money judgment entered. We'd ask for a writ date of June 23rd, 2025.
Judgment to the plaintiff by default for possession. No redemption amount, writ to issue the 23rd. Arbor Meadows versus Jaywin Root.
Your Honor,
Yes.
I just spoke with Ms. Robin Root, who's in the courtroom. Ms. Root, you want to come up?
See Jaden Robin Root.
Sorry, Mr. Jasmine Root is deceased.
Okay.
We have not entered an appearance in this case, but Ms. Root did reach out to me asking me to review this consent judgment that was signed. And I did review it for her, and I had some concerns about it that we wanted to bring forward. I was hoping to talk to counsel before the case was called to see if we could.
I'll pass it.
Thank you, Your Honor.
Thank you.
Court calls the case of Esquapas versus Christine Griffin.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff, Mr. Dennis Quapis, who stands to my right.
And Pat Quappas. Christine Griffin, no response. You've been sworn. You may proceed.
Thank you, Your Honor. We'd request a default judgment, possession only, no money judgment to enter. There's a rent to retain of $3,420, costs in the total of $175.69 for a total of $3,595.69. And we'd ask for a writ date of June 23rd, 2025.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ issue.
Thank you, Your Honor.
Thank you. And let me know when you're ready on that other one. Augusta Woods versus Anthony Wilson. That matters discussed. Court calls the case of Arbor Manor versus Patrick Brooks.
Thank you, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff.
Brooks is also.
Patrick Brooks.
Yes.
All right, there you are. All right. Where are we on this case?
Thank you, Your Honor. This case was adjourned. As you will recall, there were repairs that were made to a pipe behind the wall. The defendant has failed to pay rent, even though the repairs had been made. He was not giving access to the landlord to do the drywall repairs, and you told him to do that. He did provide access, and the drywall repairs have been made. The amount of rent due is $2,957. The last payment he made was in February, for $101. Court cost of $178 for a total of $3,132.
Repeat that number for me.
$3,135.
All right. Mr. Brooks,
Yes, sir.
the repairs have been made.
Yes, they just finished the drywall last night, but they have a couple more things to work on, which I'm not that concerned with. I was really concerned about the drywall because that was the main thing.
Okay. And so when is the rent going to be paid, sir?
I just need a little time. And a question I have, so even though I wasn't able to stay there for the past couple months, I can't be compensated in any kind of way for that.
The drywall repairs were behind the toilet. They had no effect on the habitability of the unit.
No, but they had to fix the drywall because the pipe was cracked, so I wasn't able to flush the toilet due to the fact I wasn't able to stay there because I couldn't use the bathroom.
I understand they made the repairs promptly, but couldn't finish the drywall because access wasn't provided.
All right. Well, I had requested or had ordered a written answer to the complaint, did not get a written answer to the complaint. But, you know, if you're disputing the amount that's owed, then I'll sort it out. I'm going to set this matter for non-jury trial for July 1st. 2025, 9 a.m. That is in person for both parties. And that's a Tuesday. So we'll
Thank you,
hear
Judge.
everything and then I'll render my decision.
Thank you, Your Honor.
What just happened in the Brooks case is more legally important than a simple adjournment. The landlord says the plumbing and drywall work were completed, while Brooks argues the toilet problem made the unit unusable and may justify a reduction in rent. That creates a factual dispute over habitability, access, timing, and the amount actually owed. Judge Simpson cannot fairly resolve those questions through a quick default-style ruling, especially after Brooks directly contests the balance. The judge also notes that Brooks failed to file the written answer previously ordered, and that is a serious procedural mistake because defenses such as uninhabitable conditions, rent abatement, or improper repair delays should normally be clearly preserved in writing. Still, the court chooses substance over technicality and sets a non-jury trial. At trial, Brooks will need more than a general complaint. He will likely need dates, repair requests, photographs, messages, and evidence showing how long the toilet was unusable. The landlord, meanwhile, will want records proving prompt repairs and denied access. Do you think Brooks has enough evidence to justify withholding months of rent, or has his failure to document the dispute already weakened his position?
Thank you. Court does call the case of
In the
Sycamore
meantime,
Meadows.
Judge, could I get
I'm sorry.
could I get a breakout room with Mr. Brooks in the meantime? And then we'll just,
Mr. Brooks, do you want to meet in the breakout room with him? All right, yeah, we'll put you into a breakout room.
thanks, Judge. Have a good-
Sycamore Meadows versus Chabria Story.
Good afternoon, Your Honor. Attorney Carrie Zanin, P67390 on behalf of plaintiff.
Good afternoon, you have Emily Brophy, 88273.
All right. Where
Judge,
are we on this case?
this started with us being in front of you because of an order of eviction. So, Judge, I'm withdrawing the writ at this time.
All right. We'll indicate that the writ is withdrawn.
Thank you.
Could you potentially indicate that the judgment amount has been satisfied?
Pardon?
I can't do that at this time. I don't have that documentation to show that, but I'm sure that it is. And give me a week and if I can get it done, I'll get it done.
Thank you. Sycamore Meadows versus Tarad LaFleur.
Again, Carrie Zanin on behalf of plaintiff, Your Honor.
Your Honor, I believe Ms. Lee was going to appear on this.
Is that who you were talking to? Miss Lee?
I haven't spoken to anyone today. I was supposed to meet someone today, but I haven't spoken to anyone today.
I do believe that
I'll pass it. Have a seat. Sycamore Meadows versus Erica Jemerson.
And Carrie Zanin on behalf of plaintiff, Your Honor.
What?
I believe Ms. Lee is also.
Then I'll deal with it. I passed it. I guess Miss Lee is dealing with it, so as soon as they get back in here and she graces us again with her presence, I'll call. All right, Miss
Okay,
Sains.
Judge, I don't believe I have an appearance for either, but on either file yet, so.
Yeah, I know, I never do, which is really irritating, but
Okay.
I understand your frustration.
Thank you, Judge.
Avalon Housing versus Yolanda Shepherd.
Good afternoon, Your Honor. Jillian Engen for plaintiff.
Good afternoon, Your Honor. Andrew Campbell, on behalf of the defendant. We have talked, Judge. I believe opposing counsel wants additional time, and I have no objection to that to respond to the motion. Oh, sorry. If my client is here as well, Judge. We have no objection. We're still trying to work out a
I
settlement.
thought we were resolved. Or going to be.
We were trying to resolve. I believe there's.
What's the hang up?
Your Honor, so Ms. Shepherd is first in line for new housing. I think that once she has new housing in surrender's possession, I think that this case will be moot, and so we'll be able to hopefully dismiss it at that point. And Your Honor, I also, I don't know if has Your Honor signed the order that was submitted under stipulation? I don't know that we have a copy.
Right, that's correct, Judge. And
The order prohibiting occupancy on June 4th. I have just signed it.
Thank you, Your Honor.
Yeah, and that's, Judge, just for the record, that's not a final order because we still have.
I understand that.
Okay, I just want to make it clear, Your Honor, I'm sorry. And did you want a deadline?
Your Honor, could you adjourn this for 2 weeks? We will respond to the motion for summary disposition by the 25th. I think that's the 21 days since it was served. And then I think Mr. Campbell also asked for a reply to the answer. And so we will have that submitted as well by the 25th.
I'll set this for the motion, for hearing on the motion, and yeah, I'll just set it for that at this point. July 1st, 2025, 9 a.m.
Thank you, Your Honor.
Court calls the case people of Evergreen Apartments versus Kayla Smith.
Plaintiff?
Hello,
Hello,
what's your name?
Kayla Smith.
All right, where are we on this?
Your Honor, Ms. Smith has brought her balance down to $516.41 inclusive of costs.
How much?
$516.41.
You go. No, I know. I know.
And Your Honor, DHHS is paying the remainder, so
They're gonna be-
we need some
okay.
extra time for them to get that paid. If I think a week should do it because they were supposed to submit payment on the.
Okay, my next available date is the 27th, so what I'll do is I'll adjourn it to June 27th, 2025 at 2 p.m. That's an in-person hearing, but if everything's paid, you're good.
So I don't have to come if everything's paid.
Don't
Sure.
look at it like that's a favor. You don't want to come see me? Is that?
I mean,
no,
I like
that-
you,
no, No, that's
but
okay. That's
child care is hard.
no,
to
I'm
find.
hurt. My feelings are hurt.
Okay, 26 days.
Now answer your question now. If everything's paid, you don't have to show.
Okay, good.
Okay,
Thank you.
just double check it. You may want to call.
Verify with Sydney.
Okay,
Sydney
okay,
will keep you updated.
okay.
All right, you have a great weekend.
Thanks, you too.
Flomar Apartments versus Caden Duford.
Jillian Engen.
You got him in all.
He did check it.
Caden Duford, can you check that? Huh? Yeah.
And Your Honor, just so you know, we are requesting leave to amend. There was a 1 month notice to quit sent. And so
Got it.
requesting leave to amend.
No answer. You're sure he was here? Yeah. And you're sure they were here?
Someone answered yes when I called Kate and Newford.
All right, let me pass it.
Thank you, Your Honor.
Glencoe Hills versus Tillman McCommons.
Jillian Engen for plaintiff.
Hello. Hello, sir. Your name?
Tillman McCommons?
All right, this is your motion to set aside the judgment?
Yes.
What's the basis for the motion to set aside, sir?
I was here last time. Finch, he gave me the wrong time for my appointment. Then he left and
Got it.
went into default.
Okay. Did you? This was the one in
Yeah.
okay. So apparently there was a time that issue. He was here, but his time was wrong. So I'm gonna grant his motion to set aside.
I believe, Your Honor, that we have filed a writ, and so, we can withdraw that.
Yes, and the writ's withdrawn. All right, and balance is what at this point?
I have a balance, including court costs, Your Honor, let me just verify this, of $4,373.71.
All right. And sir, how are you intending on getting that paid?
Well, I can pay today. I got like 1,300.
All right, have you tried to work something out with the landlord regarding?
I've been corresponding back and forth with her about that. And when I talked to her last time, she said my judgment was like 1660.
Well, your judgment was 2888.15. I set that judgment aside, but that was from May.
Okay, and then I came in to pay the motion. I paid like 1,200 for the
You
motion.
put 1,200 in?
Yes.
You certainly did, sir. He put $1,254 in. And you have how much today?
I like 1,200.
Gonna bring it down below 3,000.
Right. And are you working with Hawk at all?
I got denied.
Okay. All right, let's do this. I'm going to release the escrow to the plaintiff. Okay, so what you put in, I'm gonna order it released to your landlord.
Okay.
Okay, you have 1,200. I want you to pay the 1,200 today to the landlord also. Okay.
Okay.
And then what I'll do is I'll adjourn this out to June 27th, 2025 at
2 p.m.
2 p.m. to figure out how we're going to deal with the rest of the balance.
Okay.
Okay?
Yes, sir.
All right. Thank you, sir.
This ruling shows how Judge Simpson separates a procedural default from the underlying debt. McSins explains that he appeared at the courthouse but was given the wrong hearing time, and the court appears satisfied that the default resulted from a scheduling or communication problem rather than deliberate non-appearance. That gives the judge a fair basis to set the judgment aside and withdraw the writ. But notice what the judge does not do. He does not erase the unpaid balance or reward delay. Instead, he releases the existing $1,254 escrow to the landlord, orders McKins to pay another $1,200 immediately, and adjourns the case to address the remainder. This is strategic case management. The tenant regains the right to be heard, while the landlord receives funds that are not genuinely disputed. McSins also reveals a credibility problem when he first references a much lower judgment figure, but the record shows a larger amount and continuing rent accrual. His willingness to make substantial payments helps him, yet the court still needs a realistic plan for the balance. Would you view this as a fair compromise, or should the landlord have received judgment immediately once assistance was denied?
Court does call the case of Glencoe Hills versus Devonta Jackson and LaChina Williams. They did ask for what?
To appear soon. I don't have either individual.
Devonta Jackson, LaChina Williams. Neither are here. Would you like to take it to call?
No, I'm here.
Oh,
here.
you're here. Okay, your iPad. She usually has her name on. All right, go ahead. Okay, folks, I need to move this docket.
Sorry, Your Honor. Jillian Egan.
All right, this is LaChina Williams. She's here and didn't even credit me for getting her name right. No, I'm not going to say anything. Don't worry about it. Everybody's been hurting my feelings today. All right. How much do we have owing on that?
A balance including court costs of $3,031.61. I have an update from my client that Hawk is, that they are currently on a waiting list for funding. They're hoping they can make the request soon, and they will reach out when they have more funding and can submit the request.
Okay. But we don't have an idea as to when that's going to
Exactly,
happen.
right.
So are they thinking that it's even going to be before the end of the month, or we don't know?
No, sorry.
All right. Well,
Your Honor,
yes.
if, maybe if defendants could put some funds into escrow with the court, then it wouldn't necessarily, if they can, I think, I mean, they're over $3,000 right now.
Right.
You can get that paid down and then any extra put.
Ms. Williams?
Yes, I plan to pay it down as much as I can, but I know I won't be able to pay the whole balance. That's why I was just gonna wait on Hawk.
Okay.
Because I know July charges are gonna come in effect as well soon.
Yes. So let me ask you this. If I ordered you to pay funds into court escrow, how much do you think you can pay?
I could pay $400.
Okay. So let's do this. Give it a chance to try to figure it out. Pay $400 to court escrow. All right. And that means you come down with cash to the court and put it in there. Okay.
Okay.
And so get that in, and then I'll adjourn this out to my next date, the 27th, 2025 at 2 p.m. And then we'll see exactly where we are. I may have to issue a judgment at that time, but at least we'll see, we'll know for sure where we are. Okay.
Okay. Thank you.
Thank you.
Mhm.
Court calls the case of Hamilton Crossing 1 versus Victoria Bolton. Hello.
Hello,
What's your name?
Victoria Bolton.
Thank you. All right. And where are we on her case?
I have a balance including court costs of $2,237.
All right.
And I made a payment last week as well, and I plan on making one today.
Last week
You-
of $300.
Yeah,
Okay, I see that on the ledger.
Okay, was that taken into account?
Yes, Your Honor.
Okay. You said you plan on making another payment?
yeah, but I feel comfortable putting in escrow right now.
Pardon?
I feel more comfortable putting it in escrow through the court versus giving it to them.
Why?
Because I just have a lot of pending work orders that's from like January. They don't really like repair anything. They told us if it's
All
not
right,
an
so how much
emergency.
are you gonna put into escrow?
Well, today I'm gonna do 300.
All right, you need to put $300 into escrow. You need to give a written list to the landlord of those repairs.
Mhm.
Okay, that you're saying that are going to be needed.
Okay.
And you're to do that by,
Mhm.
you're to do that by this Wednesday, the 18th,
Okay.
with a copy of that list to the court.
Okay.
And then I'll adjourn this matter to June 27th, 2025, 2 p.m.
Okay. Thank you.
Thank you. Crossing 2 versus Ashley Jordan.
Jillian Engen for plaintiff.
Hello. Your name?
Ashley Jordan.
It's a termination.
And I have-
Yes, Your Honor.
I have not had a chance to speak with Ms. Engen yet, but I just spoke with Ms. Jordan, and we had spoken before about her situation. And I'm willing to enter an appearance in this case, but I'm hoping that we can work it out with Hamilton Crossing.
Will indicate here that legal services is going to enter an appearance. And what I will do is I'll adjourn this out June 27th, 2025, 2 p.m.
Thank you, Don.
Thank you, Your Honor.
Thank you. Hamilton Crossing versus Jessica Jackson. Hamilton Crossing.
Jillian Engen for plaintiff.
Hello.
Hi.
Your name?
Jessica Jackson.
All right. What's plaintiff's claim in this case?
I have a balance including court costs of $1,118.
All right, so she got that $1,000 in. How are you gonna get the rest paid?
I have a money order in my car for 500.
You have a money order in your car.
Yes.
Why'd you leave it in your car? No, never mind. Nah, okay, I don't.
Cause I had
You
just,
got 500 in the car.
yes, cause I had just got paid and I didn't want to be late for court. So,
You didn't want to be late for court?
No.
Oh,
so.
Valid.
that's
Valid.
that's nice. That's nice of you. Okay, so you have 500. Then how long is it gonna take to get the rest of that? You got about another
I have to pay Friday. Next Friday.
the 20th next Friday or the 27th?
What's today?
Today's the 13th. So 2 Fridays from now would be the 27th.
Okay,
And
18. You said
next Friday's the 20th.
20.
You'll have it paid by the 20th?
Yes.
All right, so what I'm gonna put in here, you pay $500 to the landlord today.
Mhm.
All right, and then I'm gonna mark that you're gonna pay the balance by the 20th. I'll adjourn this matter to June 26, 2025 at 2 p.m. If you've got everything paid, I don't need to see it, not that I wouldn't want to. Okay, before you hurt my feelings and say you don't wanna come see me, all right?
Okay, thank you.
I'm sorry, it's the 27th then.
27?
Yeah,
Okay.
next Friday.
Thank you.
All right, or 2 weeks from now. Court calls the case of Hamilton Crossing 2 versus Jeffrey Williams.
Jillian Angus for plaintiff.
And hello.
Shirley. I'm Shirley Williams.
All right. And what's the claim now?
I have a balance including court costs of $811.
All right. How
I'll
are we
be
gonna
paid
get
on-
that paid?
On the 20th, I'll be paid.
You can pay it all on the 20th?
Mhm.
All right, then I'm gonna you're gonna pay 811 on the 20th. I'll adjourn this out to June 27th, 2026 or 25. I don't know why I want to do this. I don't know why. At 2 p.m. Okay?
Thank you.
And if you're paid, I don't need to see it.
Okay.
All right.
Thank you.
Here, well, let me break in here real quick and try to get Miss Zana now. I think they said they're ready. Are you ready on the Sycamore Meadows cases?
Yes, sir.
Sycamore Meadows versus Erica Jimerson.
Again, Carrie Zanon on behalf of plaintiff, Your Honor.
Emily Rose, the AHU.
All right. All right.
Judge, we
What are
are
we doing
working
on
to
this
resolve
case?
this. We are trying to work to resolve this. Can we adjourn this to the June 27th date?
Any objection? Case is adjourned June 27th, 2025. What time are they? At 3 p.m.
Thank you, Judge.
Thank you. Sycamore Meadows versus Tyrod LaFleur.
Again, Carrie Zanon on behalf of plaintiff.
Again, Emily Rose for defense.
All right, what do we want to do? Hello, Miss.
Judge, the same thing as the previous. Can we adjourn this to June 27th?
All right. All right, Mr. LaFleur, I'm going to adjourn your case out to June 27th, 2025, 3 p.m. Okay. All right, thank you, sir.
Thank you, Your Honor. Have a wonderful weekend. Happy Father's Day.
You do the same. Were you ready? Court recalls the case of Arbor Meadows versus Jaden Ruth. Jake Winnie.
Good afternoon again, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Good afternoon, Your Honor. Officially, I will be entering my.
Robin Root.
Of Ms. Root.
All right.
And I believe counsel and I have agreed that we are going to submit a new conditional order of dismissal in this case with some additional protections for the defendant in that she will be required to maintain the home site in accordance with rules and regulations of the park for 12 months until June 10th, 2026. But if plaintiff alleges that there has been a violation of those rules and regulations, they will notify us as counsel and Ms. Root and give us an opportunity to respond and object and have a hearing.
Is that basically it, counsel?
That's correct, Your Honor.
Are you guys going to put that together? And
I'm going to draft a conditional order of dismissal this afternoon, Your Honor.
all right. Then I'll adjourn this out to June 27, 2025 at 3 p.m. If you guys have that, then I can enter it if both sides are represented by counsel.
Thank you.
Your Honor.
Thank you. Court calls the case of Huron Vista Apartments versus Sabria Williams.
Andrew Campbell, on behalf of the defendant, Your Honor. I believe we needed a ledger, and Ms. Ingen is going to give me one today, Your Honor, so that we can have time, so we can get an updated amount and get that paid, Judge. So I believe opposing counsels will consent to an adjournment of 2 weeks.
Yes, Your Honor, we're happy to adjourn. And for the record, the court, the total balance, including court costs, is $478.
478.
Yes.
June 27, 2025.
Thank you, Judge.
2 p.m.
Thank you.
Thank you. Court does call the case of Huron Vista versus Alicia Moore.
Jillian Ingen for plaintiff.
Not checked in. Would you like to take it to vote?
Yes, please, Your Honor.
All right, I don't think I've sworn you in. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $4,485, court cost of $176, for a total of $4,661. Plaintiff is requesting a default judgment for possession only with a writ to issue after July 5th.
July 5th.
2025. Your Honor, we're going to set this aside if if Ms. Moore pays $1,661 on or before July 5th, then we will set this judgment aside.
Gotcha. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue as indicated July 5th. Court does call the case of Huron Vista versus Jacqueline Taylor.
Jillian Ingen for plaintiff.
Good afternoon.
Okay, she's here. Your name, please?
Jacqueline Taylor.
Thank you. All right. Where are we on?
Your Honor, I have a balance including court costs of $2,413.03. I believe that we are looking to enter, I believe that Ms. Taylor is participating in the forgiveness plan.
Okay.
We'll be drafting a conditional order of dismissal.
All right. Is that correct, ma'am?
Yes.
All right. Do you want me to adjourn this out?
Please, Your Honor, to the 27th.
Okay, ma'am. I'll adjourn your case to June 27th, 2025 at 2 p.m. All right?
Yes, sir.
All right. And hopefully we'll have everything all resolved by then. All right. Take care.
Okay. Thank you. You as well.
Court does call the case of Huron Vista Apartments versus Danielle Davis.
Jillian Ingen for plaintiff.
Danielle Davis has not checked in. You may proceed.
Your Honor, I believe that this is a motion hearing.
This is a motion to set aside default. Danielle Davis, defendant having failed to appear, motion to set aside is denied.
Your Honor, may I ask, is there escrow in this matter?
Yes, we have $500 in escrow.
Okay,
So escrow to plaintiff.
thank you, Your Honor.
Across this docket, Judge Simpson applies one principle. Possession cases require fairness and concrete proof. Defendants who failed to appear faced default rulings because the court had sworn testimony, stated balances or violations, and no opposing evidence. But when a tenant appeared and raised a dispute, the judge avoided rushing to eviction. Brooks received a trial on habitability and rent calculations. McSins had his default set aside because the wrong hearing time may have caused his absence, but he was still required to release escrow and make an immediate payment. Other tenants were ordered to deposit money, provide repair lists, or meet deadlines. Those conditions matter because verbal promises alone do not protect either side. The final Davis ruling reinforces the key procedural lesson. A party asking to set aside a default must appear and support that request. When Davis failed to attend her own motion hearing, Judge Simpson denied the motion and released the $500 escrow to the plaintiff. The court was not declaring every landlord allegation correct. It was enforcing the requirement that the person seeking relief must prosecute the motion. The takeaway is clear. Document repairs, preserve defenses in writing, attend every hearing, and bring proof of payments or assistance. Do you think Judge Simpson gave tenants enough opportunities, or did some receive too many extensions? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.